Good morning, WTOB listeners. This is Dylan Greenwood here with Jessica Armentrout, and this is For the Record with Greenwood Law. Today we're going to be talking about adoption here in North Carolina. It's a bit of a change up from what we have been doing. We've been going through different constitutional right issues, your right to remain silent, your right to an attorney, your right against illegal search and seizure. But one of your constitutional rights here in North Carolina is the right to be a parent. Mm-hmm. And a way in which that can come about for a lot of people is through the process of adoption. And generally speaking, and when it comes to family law, a lot of things in family law are sad. Let's just be honest. A lot of things are coming to an end or families are breaking apart. But when it comes to adoption, that tends to be one of the happier things. A lot of times it's because maybe the child's getting placed in a better situation, a family, that maybe may not be able to have a child or whatever. Now they're going to finally be able to be parents themselves, and they're offering a home to a young man or young woman. And then all of a sudden, that's certainly a happier situation, isn't it?
It is, and you're right. It is one of the limited times in family law where kind of things are beginning and starting and becoming better. I guess the occasional prenup is happy because they're getting married, assuming there's not too much involved in it. And the occasional divorce can be happy if it ends the right way. But generally, adoption is almost 100% of a happy proceeding. Sometimes the things leading up to adoption can be a little bit more strenuous. It's not as simple. Sometimes it can be simple, but it's not always, because like you said, the rights of a parent are taken extremely seriously in North Carolina. And so if your child were to be adopted, then your parental rights would have to be terminated, assuming that you don't just consent to the adoption. And so to terminate someone's parental rights, you have to go through all these things. You have to show abuse, neglect, dependency. You have to show that the parent has not acted as a parent. They've not financially supported the child. They've had no contact for 6 months. Things like that. And sort of without those factors, if you don't want your rights to be terminated and don't want your child to be adopted, you can possibly stop the adoption or stop the termination of your rights that would then make the child available for adoption.
So how exactly does that happen?
So there are two kinds of terminations of parental rights. One is the private termination, and one is usually done through DSS. That's probably the more common one. DSS, when they take a child into their custody, if the parents haven't met certain milestones in their reunification plan, then they can petition to terminate the parent's rights, assuming, again, all the grounds have been met. And if they terminate the child's rights, then they would have the responsibility of placing the child for adoption if an adoptive family isn't already waiting. And sometimes they are for certain children. And then there's a private termination of parental rights, and that is most commonly done by step-parents that want to adopt a child. So stepfather, it's been in the kid's life for 5 years, wants to adopt the children, have to terminate the biological father's rights. Or sometimes a third party, like grandparents that have custody of a child, if they haven't heard from the parents in 6 months, haven't received any financial support, can show the neglect and dependency stuff, then they may be able to terminate the rights as well. If parents are willing to consent to the adoption, then you don't necessarily have to go through that step, but people just aren't always willing to do that.
Right. And, we get calls quite a bit where people are, they call us up and they say, well, my ex or, somebody I was with, the other parent of the child, they're saying they want to sign over their rights. Mm-hmm. And you hear that all the time and you go, well,
it's not quite as simple as that. They just want to sign over their rights. A lot of times that has to do with child support. They want to sign over their rights because they don't have to pay child support anymore. Otherwise, just do child custody. But North Carolina doesn't really provide a way for you to just sign over your rights other than the consent to adoption. So, if I had a child with someone and he wanted to sign over his rights, unless I've got somebody waiting to adopt that child with me, then he can't just sign over his rights in that sense and absolve himself from all responsibility. The state of North Carolina doesn't permit that because that leaves a child without an avenue of support
Right.
and might make them a ward of the state. So.
And we've talked on prior shows about how North Carolina takes very serious.
Right, and we have touched on that child support thing before, but
yeah.
it comes into play in a lot of places.
Yeah, absolutely. And I mean, it makes sense that it comes into place here. And so, basically, if you're so willing to not want to pay child support that you're willing to, give up your child for adoption, then that means you have no rights to your child at all. I mean, if you're consenting to that, yes, there's no child support, but there's also no rights as a parent anymore.
Right. You couldn't come back and try to reassert those rights later. You couldn't come back and necessarily file for custody as a third party since you're not technically a parent anymore. When it's for real, it's for real.
I think the only way that you could do it that I'm aware of, if you come back and try to re-adopt your own child, which I do know is possible.
It's possible, but it's a little bit odd.
and it's very rare.
I've not personally had to deal with that one.
Right, but there is an avenue for it in the law because adoption is one of the unique parts of the law that it's purely statutory. That it's not, there's no common law right to an adoption. We've talked about common law on this show before about how that's the law that comes from, basically we base a lot of it on where our justice system, legal system came from, which is England. And then we use a lot of the prior cases to build up all this case law that becomes precedent. And we rely on that, and that's common law. It's not statutory law. There's no common law right to adoption.
No, it's more of kind of the statutes just really lay out a process. A process and some eligibility requirements really is kind of what it does. And if you meet those, then you can initiate the process, see it through. But that's, you don't have necessarily a right to an adoption, but you do have a right to prevent the adoption, again, if you want to protect your parental rights.
So you said that there are certain eligibility requirements. What are eligibility requirements to adopt?
The person that's attempting to adopt, then they would need to show that they can provide the good home, again, assuming that there needs to be a review of the home. If the child has already been with that person, or if they're an immediate relative, then they won't necessarily have to do that placement assessment to check out the house and make sure it's appropriate. But if the child hasn't been with the person very long or not an immediate relative, then DSS or some other licensed agency can do what's called a home study, make sure you're eligible, that kind of thing. And then you would have to check on the eligibility of whether or not the parent's rights have been terminated or they've consented. Even if the parent doesn't consent, you could still adopt in kind of a limited circumstance as long as the parent is noticed that an adoption proceeding is happening. So if for example, this happens more often with dads than moms, but I think it can go the other way too. If grandparents are trying to adopt a child and mom is signed to consent and dad is not really easy to find or hasn't been around, that kind of thing, and if you want to just file the petition for adoption, as long as dad is properly served with that petition, if he doesn't object, then the adoption can probably go through.
It's almost like implied consent.
Yeah, it's sort of. If dad does come back and say, no, I don't want the adoption to go through, you need my consent, then there actually can be a hearing to determine maybe dad's consent isn't required. If he's not stepped up and paid child support, he hasn't established paternity, he's neglected, those things can be heard by a judge in district court, and then dad's consent just may not be required. So that's kind of the only way around the termination of parental rights.
So does that become a best interest of the child standard, or do you not even get
that
to that
one
point
actually
yet?
Is not. If you're just going to determine that you don't need a parent's consent because they've behaved a certain way, it wouldn't even necessarily be a best interest of the child. I don't even think you would put on much evidence as far as the fitness of the adoptive parent. It would just be, he doesn't have the right to say yes or no. He's kind of, I guess the best way to say it is he's abandoned or neglected his rights.
So I guess the thought process there is that they have shirked their constitutional right as a parent. They haven't asserted it in any way.
Right.
And so because of that, they've effectively already terminated it.
Yes.
And then if you're coming back at such a later date and saying that all of a sudden you want to do it, well, why don't you do it at any other time before this?
Yes. That's kind of the idea with that. And if you proceed on an adoption without that parent's consent, and you do have a much longer window of time for that parent, assuming they find out about the adoption much later. They have about a 6-month window to appeal it rather than a normal 30-day if they weren't noticed properly, or even if they were noticed but they didn't have the chance to respond. And because the TPR statute, Termination of Parental Rights, has a kind of corresponding 6-month factor in it if the parent hasn't had any contact for 6 months, I think those kind of play together, because if you haven't noticed your child was adopted in 6 months, then
you're not really part
you might
of
have got terminated
child's
anyway.
life. Yeah.
The odds are good you might have had your rights terminated anyways.
Right. No, that makes perfect sense. And that notice aspect actually came up a little bit, and there's some other issues, but it actually came up in a recent court appellate case that happened with adoption, where it was and this is, I hate to say that it's a common occurrence, but this happens more than you would think. You have a teenage couple still in school, get pregnant, and girl switches schools, and they're trying to. It was said that they tried to notice the dad, who's also a teenager. The address for the notice was filled out incorrectly, so there were all these attempts never went to dad. Dad ends up finding out later, after the child had been given up for adoption to an adoption agency and placed with a family. Once dad finds out, then dad comes back and tries to assert his parental rights.
Yes, and these are very young teenage parents. Like, it's, in the opinion, it's sort of strange to read it because they talk about the decisions that these kids made. You got to remember, they are kids. The mother of this child was 14 and the father was 15. So it's not that, that's just a really, really young age to be making those kind of decisions. And it even does mention that it was probably the adults in their lives that were making some of these decisions, for better or for worse. But it's still a lot to put on 14 and 15-year-olds. But the child was born in October of 2017, placed with the adoptive parents, or mom signed her consent in November of 2017, so when the kid was about a month old. And then this child had been with these adoptive parents kind of since then. And then dad was noticed with the petition for termination of his parental rights a couple months later, I believe in March or May of 2018. And once he was noticed, he did make some efforts. He had a paternity test done. He had all these things that he tried to take the appropriate steps at that time, or someone helped take them on his behalf. But it's, either way, the natural family of this child was asserting its rights. And so then they had subsequent hearings. I think the dispositional phase of it took place over 2 days in late 2018 and then finished up in January 2019. And the Supreme Court didn't come out with an opinion until December of 2020. And so this was a long, drawn out process that this child was with the adoptive parents for at least 14 months that we're aware of. I can't tell from the opinion where the child went after the TPR was denied, because the court didn't terminate the dad's parental rights. They said he had not been allowed the opportunity to assert his rights, and therefore it would be unfair to terminate them. And in that case, the court kind of mentioned that the value on his rights were placed at least at the same level as the best interest of the child, because there was nothing bad about the adoptive parents in there. They could be very nice people, but that didn't necessarily trump the fact that maybe the dad could have been a good dad. He just hadn't had the opportunity to do that yet. And then the court also found that even though the child was bonded with the adopted parents, because it was 14 months old, severing that bond wouldn't have a lasting impact on the child. And there's probably some healthy room for debate on that issue. That's
quite a thing for a court to assert.
It is, and I think they based it on some kind of research or a study, so I don't think it was totally based on nothing. But again, it wasn't, at least the Supreme Court's opinion wasn't necessarily based on this child, because they didn't know this child. But that's sort of where the discretion was left up to the trial court that decided dad was able to get another chance.
And the Supreme Court actually went a step further and kind of made an implicit judgment on adoption in general.
Well, the trial court judge had made an
That's
implicit judge on adoption. They, the judge down there, and I actually don't know if it was a male or female, said the change in caregivers' routine and home must be balanced against the harm that children who are adopted often face as they try to understand who they are, where they came from, and why they were not raised by their biological parents. So that caused a little bit of a controversy about what that statement was saying about the idea of a child being adopted and how that in itself is a little bit harmful. And the Supreme Court did say that was an inappropriate bias, or at least an inappropriate bias was shown in that statement. And so it's actually been remanded back to the trial court for either a new hearing or other findings regarding that issue, because it seemed to weigh a little heavily in the mind of the trial court judge, at least based on the way the Supreme Court read it, that maybe she was biased against adoption rather than just
this particular situation,
protecting the rights of this particular father.
And that's so interesting because, as we mentioned before, adoption is purely based in statute. That's where it comes from. And the reasoning behind that was there was a policy interest. We deemed that there was a societal policy interest in saying that adoption's a good thing. Let's try to get kids placed in good families. If families want them, they don't need to be in perpetual foster care or out there on their own or in a situation where people don't want this child around. Get them with people who want them, which makes all the sense in the world to do. And then all of a sudden you get this statement from a member of our judiciary that flies really right in the face of that. Is quite intriguing.
It was certainly read that way by the Supreme Court, and I see how it could be, even if it may not have been exactly the way the trial court judge intended it. And also, sometimes trial court judges don't necessarily write their own orders word for word. Sometimes they're written maybe in a larger county by a clerk, but sometimes they're written by the attorney for the prevailing side. And so the attorney for the prevailing side might have put that in there, and the judge may not have quite meant it the way that it was read in there. I would try to give the judge the benefit of the doubt on that.
That's fair.
That might be what has caused some of the blowback then is that this kind of slid in one way or the other, and if it was put in by the respondent's attorney, it's kind of hurt their own case a little bit, because now it's come back for basically a new hearing.
I find it one of the more interesting things about this is who actually brought the appeal, which was the adoptive agency.
Because they did not prevail, and they wanted the guy's rights terminated, and he won, so they appealed on that on a few different grounds. But I guess they could maybe consider this a little bit of a win because they get sort of a partial bite at the apple again, but it'll be interesting to see. And I don't actually know where the child has been during this time. I don't know if after dad prevailed on this hearing, if there was a custody action filed and child's gone back to dad for a while, because I would think by the time they redo this hearing or stuff, it's going to be a lot longer than 14 months.
Right.
Depending on where it's been.
So with it going back down to the trial court judge, would the trial court judge look at best interests of the child between biological father and adoptive parents, or does it even get to that analysis?
So that's supposedly one of the factors in the analysis for termination parental rights is the bond that the child has with the natural parents and the bond that it has with the adoptive parents. And they said this child does have a bond with the adoptive parents. It doesn't have one with the father, but that's not necessarily his fault. That was sort of the equities that they were weighing there. And so I don't know if that calculus is going to change much between now and when they go back for it, because it'll sort of depend on where the child is and what steps people take in the meantime.
If you're just joining us here on WTOB, this is For the Record with Greenwood Law. I'm Dylan Greenwood here with Jessica Armentrout, family law attorney here at Greenwood Law. And we're talking about adoption as it relates to North Carolina and all the different rights that people have with adoption, parental rights. Kind of keeps with our discussion that we've been doing on different constitutional rights, and North Carolina gives parents a constitutional right to be a parent. But one of the things about adoption that I think is important for people to know and understand is that a person or business entity or what have you, except for certain caveats that are carved out particularly by statute, cannot pay, give, or offer to pay or give any money or anything of value that relates directly or indirectly for the placement of a minor for adoption, the consent of a parent or guardian to adopt a child, or for the relinquishment of a minor to an agency for the purposes of adoption, or assisting a parent or guardian in locating a potential adoptive parent. So those things cannot be bought and paid for, not just with money, but anything of value. And the reasoning behind that is there was a time period where basically there was a market for the buying and selling of children. And we have said that that is not a good thing at all. That's basically human trafficking. And we, because of that, and that would fly right in the face of human trafficking laws and statutes, we have said that that is not allowed as it relates to adoption, because that would be an easy loophole to get around what is otherwise a criminal activity.
Also disproportionately impacts lower income people who might be more inclined to sell their child to a...
Yeah, I think that was thought of it with that too. But what can be done is an adoptive parent may pay certain reasonable expenses and fees as it relates to the pregnancy of the mother of the child. So basically, hospital bills, medical expenses, traveling for the purposes of getting the child to a certain place or having the child at a certain hospital, whatever it may be. So it's kind of these ancillary costs. They're not paying for the child itself. They're facilitating the child having a healthy birth that is monitored and overseen by medical care that sometimes may not be afforded to certain individuals. So in that aspect of it, there is a health consideration, I think, that is taken into account that far outweighs the other concerns that come with paying for adoption itself. One of the other unique aspects of adoption is that, when it gets down to it, Jessica, I could adopt you.
You could. We've talked about adoption of children that are born, the contemplation of adoption of children that aren't quite born yet with the cost, and doesn't necessarily have to be a child. Adults can adopt one another, and there are many reasons for doing that, I suppose. Sometimes if you've had a relationship with a child their whole life, that you took care of them, did all these things for them, acted as a parent, but you could never terminate rights for whatever reason. Maybe 100% of the grounds weren't met. Maybe you couldn't afford, whatever the case may be, but you still want to reflect that relationship. You can do that as an adult, because the adoptee, no longer a child, but the adult being adopted, once they're 18, they could consent to that kind of thing themselves.
That would obviously expedite the process.
And that could be, in that process, name would be changed, birth certificate would be changed, just like they were adopted as a child, or if they were the natural born child of that person. And so one of the more interesting things about that, and I can't say how much this was used, anything like that, but occasionally it was used before the legalization of gay marriage. Homosexual couples, one might adopt the other because parents and children have certain legal rights that maybe they couldn't get without a stack of paperwork and contracts and power of attorney and things like that. But if I'm in the hospital and I'm married, my husband gets to make a lot of medical decisions. If I'm not married, then it goes to my parents as my next of kin. And so these adoptions between same-sex couples would kind of establish that relationship, allow them to make medical decisions, inherit from each other without additional documents. And the problem with that, though, becomes you can't just break up. You can't, if now that they have the marriage available to them, they can get a divorce like everybody else.
So what's the divorce version of adoption?
I don't know if you could undo that. You'd have to kind of cut them out of your will. Those inheritance rights we talked about naturally creating, you'd have to go out of your way to sever. You'd have to go out of your way to appoint someone else as your power of attorney for healthcare decisions and various other things. You'd still have to do all the paperwork, just maybe at a different stage in it.
Right. I mean, I guess technically you you could, because you can petition as a, in the case of a minor child, you can try to terminate that parental guardianship over you.
Mm-hmm.
I wonder if after adoption
I guess you could have your natural parents adopt you again, or
something
somebody else
like that.
re-adopt you as an adult. I suppose, but
Gosh, that brings up
hadn't really thought about that one.
so many potential issues. It's probably a good thing certain things got legalized so that we didn't have to go down all those potential avenues.
For many reasons, that just being one on the list, probably.
My gosh, because that's fraught with peril. But I mean, when it gets down to it, anybody can adopt another person, just can't pay for it. And but as it comes down to it, adoption is generally such a positive thing.
Generally,
it really can help out a lot of people in need, memorialize significant relationships even when they're not a minor child, and afford somebody a lot of rights that they may not have otherwise had. And so for that reason, we thought it was very important for people out there to fully understand exactly what happens with adoption. So thank you for providing that insight today, Jessica.
Sure.
And thank you for everybody joining us here today on WTOB. And don't forget to join us next Sunday here on WTOB, 10:30 a.m. on For the Record with Greenwood Law. We're going to stay in the family law realm of things, and we're going to be talking about divorcing a narcissist. And it's a very intriguing issue, and we're going to bring on a special guest, Dr. Gray. And where does Dr. Gray practice, Jessica?
He's Carolina Psychology Associates in Winston.
So he's going to be talking about sort of the psychologist perspective on that. Jessica's going to be bringing the legal and the kind of the procedural aspect of it, but it should be a very interesting discussion next week here on WTOB. But before we go, do not forget that Greenwood Law Bill of Rights, and that is first and foremost, I will not represent myself in a court of law, and that includes stuff like this, family law, adoption. It's real easy to mess up the paperwork, mess up the procedures in court. It's very technical. Second thing is, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when asked by law enforcement. And 5, I will not be my own star witness for the prosecution. It's not a crime to know your rights and to assert them. Be safe, be healthy out there, everybody. This is For the Record with Greenwood Law, signing off.